Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Okay, let's go to New Jersey. This is very specific, but this language that I'm going to talk about is not so New Jersey state specific. So New Jersey has apparently at least two types of pensions for injury, and there's an accidental disability pension on top of a regular pension. So here's what happened. They have an individual who was on the ambulance. He picks up a patient, a very heavy patient, took 6 people to move this patient. They get him on the hospital or moving him to the hospital bed, and they roll up the blanket like we all do, roll up both sides, get a good grip. And he pulls with other people. He pulls also a combative patient and heavy patient, pulls him over and feels a burning in his shoulder. Turns out he tore his shoulder and can't go back to work. So he wants an accidental disability pension. He already got his ordinary disability pension. He wants accidental. In New Jersey, the law is that you can only get an accidental disability pension for something that's unexpected, external happening of the event, right? And is not a pre-existing injury or an exacerbation. So the court looks at, was this accident that happened to him an unexpected external happening? And look, in short, we know that lifting injuries all the time, especially in EMS, result in injuries. Bad form, heavy patient moves on you, equipment moves or fails on you. So the court says this wasn't accidental, all right? It's accidental, but wasn't unexpected. This is a normal thing that happens. And I think every expert witness would say the same thing, right? That yes, patients are heavy. And look, remember when you lean over to pull, right, a patient, you're putting your back down basically to pull back up. It's not necessarily just an arm movement, because not everyone's arms are wider than the table they're pulling the patient back to. It is a very dangerous motion. And in fact, I would have gone a little differently if I was the expert here, because having worked in a hospital for many years and an ambulance for 2 decades, the way that we started doing things is we put in addition to a transfer sheet, we also used a transfer board. And the transfer board, once we slid that under the patient, allowed us to, from the head and the feet, without bending over the table, move the person to the right. I don't exactly know how they did it, although they describe it like they reached over. But here would have been my question. Had they implemented safe lifting procedures and safe moving procedures, and had they safely moved the patient in accordance with those procedures that were designed to reduce the expected injury to unexpected, would that have changed things? And look, I don't know. I may be making this totally up, but from, Curt, you and me think of things in a fire and EMS perspective, right? Because we can put our heads in the scene because we've done it a million times and say, oh, wait, right? We think of things differently. The benefit of having a fire and EMS lawyer. I don't know whether they made the argument that way. I just don't know. But that's how they came out. Unexpected injury. They said it wasn't an unexpected injury, lifting and moving a patient. I would have argued otherwise if they had safe moving techniques.
I've got a different perspective on this one, and it sounds a lot like what we went through in Providence, and what we had a pension system that has two tiers, or two ways that you can retire. Well, 3 ways. One is a regular pension. Second one is a disability, but it's the intent, or at least my understanding of the intent of the disability was that if you're unable to continue to work. Now, you could be unable to continue to work for a lot of reasons, but if you're unable to continue to work and you're vested in the pension, you're going to get something. It's not going to be as much as if you made it to retirement age, but it's going to be something. So that would be a regular they call it a regular disability. You could get in a car accident and not be able to work anymore, whatever it may be, but you're going to get something, okay? And then they have a thing called the accidental disability, which is essentially a line of duty injury. If you're injured in the line of duty, then you qualify for an accidental disability pension. This is the interpretation, what I just explained has been the interpretation that everyone I know that had ever worked for the city had. And then one day, 30 years or so ago, we had a new city administration come in. And they saw a way, hey, I know how we can save some money. You see that word accidental? We're going to say that it has to be an accident. And no one had ever questioned this before. This was settled law. Both sides, by their practice, had basically, accepted that definition of accident. Accident is consistent with line of duty. Right. And so then now you have this, somebody's really a bean counter is going to make the argument that there has to be a singular accident that is going to qualify you for this accident. And, the courts at the time, whatever, politically, they were worried about cities going bankrupt and pension systems going bankrupt. And they said, yeah, we like that. We're going to buy that. And they went along with it. And the firefighters like, what just happened?
Yeah.
And that I have trouble reading a case like this and not seeing that there may be more to this story than what's going on. But at the end of the day, obviously the word accident means, has a meaning. It might not have been the intent of the parties when it was originally written, but that's the way the courts have interpreted it.
Yeah, I do hope they appeal this. It's only the appellate division. I don't think it's the state's highest court. So I do hope they appeal, if nothing else, to get this settled. New York went through the exact same thing that you spoke about. And New York's similar, we call it 207A, but similar disability talks about, well, you only get it if it's a heightened emergency or a heightened injury or performing unexpected services. And some of the courts have even said washing your car while on duty satisfies it. And literally that example.
It's the equivalent of workers' comp. I mean, if you're falling to workers' comp, you're going to get a workers' comp settlement at the end of it. Well, at least in Rhode Island, firefighters aren't under workers' comp. We're under it's a different program, but you've got to qualify for a pension. And there has to be some sort of so your work-related injuries now are going to put you under this, but are you going to get if you've only got 10 years and you just qualify for vesting in your pension, you're going to get, it won't be enough of a disability pension to live on.
Right.
Whereas if you get the accidental disability, it's going to be 2/3 of your last highest year or last couple of highest years, whatever the program.
So I would have liked to see what the legislature stated when their intent creating this law, because sometimes it starts with firefighters and EMS workers are subject to heightened chances of injury because of their profession. Mm-hmm. And the early courts screw that up by saying, oh, that means it's firefighter plus, right? It's a normal firefighter risks plus more.
There's some New York cases that, I've seen
a ton of New York cases, and they even got down to changing a light bulb is one of those risks, and putting in smoke detectors. They said that covers you if you get hurt.
I recall even if someone slipped on stairs, there was a question about whether or not there was water from the fire hose caused the stairs to be wet. If that did, that is an increased risk that's associated with firefighting. Versus you slipped on a puddle, that was there before. Right.
And that's the problem. The problem is the courts may or may not understand that, listen, almost everything we do is a heightened risk, because you may walk up a driveway with a little rain on it, right? But now put on you 60 pounds of gear, an SCBA, holding tools in the middle of the night, right? And you're trying to size up the building as you're walking up, or you're pulling something. That's heightened as to the normal person. It may not be heightened as to firefighting, but I think the laws all came to say firefighting itself is a heightened risk. So it should be, as you said, anytime you're injured performing a fire activity, it is covered. We just don't do things like a normal person. We wear weird, bulky, unbalanced gear, right? We don't just climb a ladder. We climb a ladder with 60 pounds of gear and saws. I mean, that's not normal. So that's why I say, I hope they appeal this. I don't agree with the ruling, but I'm not as familiar with this section of law in New Jersey as, to make a really pertinent case.